From the record in this case and from the studies I've seen, it's honestly all over the place. I mean, there are some people who will say that any active THC could cause impairment. I know states that have said over 5. I guess with respect to this case, when I look at the AMMA, knowing that the DUI statutes were already there, they carved out this exception to prosecute DUI only in cases where there was impairment. And the only way to reconcile that with the DUI statutes, which I think is what we aim to do, is to say that there would have been no reason to pass 362802D in the language that's there if we were just going to apply it to the A1 impairment charge, if we were just going to deal with impairment, because that was already the case.
But couldn't we reconcile it, though, with by saying if you're under 2, it's just an inert metabolite, then you can't be prosecuted, whereas arguably before the Medical Marijuana Act, under A3, it just says any drug or its metabolite, and you could arguably be prosecuted even if it's in a quantity that's not sufficient to cause impairment. Does that make any sense? What I'm getting at is it seems like you can still harmonize the Medical Marijuana Act with A3 by saying you can't be convicted of A3 if you are at, here the state's expert said under 2 there seems to be no chance of there's no chance that you could be impaired. So we are carving out something that would not be present without the Medical Marijuana Act. But we're leaving this middle area where the sides get to argue to the jury that between 2 and 5 you could be impaired. And if a jury believes that, and maybe the science will develop, but if there's testimony to the effect that you could be impaired, then it seems like you could still be convicted under A3 consistent with the Medical Marijuana Act.
Well, Judge Catani, I guess obviously there are no laws on the books at this point, like with alcohol, establishing what that limit would be. Obviously this wasn't drafted as perfectly as it could have been, but I think the intent is clear that, and I understand what you're saying in terms of the language being insufficient concentration to cause impairment. I would submit, because there's no exact number that we know where that could take place, there is no agreement. For instance, with alcohol, universally, everybody agrees 0.08, everybody's impaired. Everything I've seen, everything in the record doesn't show that there's any such number. In trying to construe the intent of the AMMA, I think it's clear that they were trying to take out that A3 prosecution for someone, because there is no such number that we can all agree on causes impairment or not, where there's definitely not going to be impairment. I think what they...
How about, do people now agree that, say, over 5, and again, I apologize for not knowing the science, but let's say it's a 10, and on this scale, according to the state's expert, like I say, it was 2 to 5, let's say it's some extraordinarily high number. Is it your view that the Medical Marijuana Act also exempts that person from any criminal sanctions for driving with this level, a level 10?
Under A3, I believe so, Judge. I believe that it does. I believe in that case you've got the perfect situation for an A1 prosecution. You can bring in that expert testimony to say, based on the amount of THC in this person's system, they had to be impaired, just like happens with the alcohol cases every day, and you prosecute under A1. Now, granted, AMMA could have easily, or would have been more clear, we wouldn't be here today if they had said, from now on, no more A3 prosecutions. I firmly believe, based on the language, based on the purpose of the AMMA, based on the immunity clause and the language they used, they meant to give immunity to medical marijuana patients under an A3 charge. And
sorry, Counsel, does your position depend on, essentially, I'm going to call it perfect driving? Because the wording in the statute says, shall not be considered to be under the influence of marijuana solely because of the presence of metabolites. Well, I guess I don't know what solely means. I'm inferring, and maybe wrongfully so, that if there's some evidence of bad driving, if you will, that this takes out your immunity. It takes away the immunity clause. help me understand that better. What is the meaning of solely because?
Sure, Judge. I believe, Judge Brown, that that is specifically the language that was tailored to provide immunity from a prosecution under 281381A3, because that's the subsection of the DUI statutes that someone can be convicted solely on the basis of the fact that they have an illegal drug or the metabolite of that illegal drug in their system. So I believe that language was tailored to provide the immunity to the A3 prosecution. It's a non-issue. Impairment's a non-issue under 281381A3. That is why I believe this was meant to say, of course the state can still prosecute DUI under 281381A1 with medical marijuana, but it provides immunity under 281381A3. Obviously, there could be a conflict of laws here, and I understand that the DUI statutes that were written some time ago certainly didn't contemplate medical marijuana. Obviously, there's several rules of construction that we look at when we talk about conflict of laws. We want to harmonize laws so that they can both be given full force and effect. Generally speaking, though, the more specific recent statute would govern. In this case, clearly the Arizona Medical Marijuana Act is more recent, and it's more specific in dealing with driving with medical marijuana. When there's a new statute that is enacted, you presume that the legislature, and I submit a voter initiative should have the same presumption, that they intended some change in the existing law. We had a situation similar to this that this court addressed last year in State versus Oken, where you had the Arizona Medical Marijuana Act and its language prohibiting the forfeiture of marijuana seized from a medical marijuana patient, and the old laws that basically said, plain reading, if you seize marijuana, you don't give it back. And in reconciling those two statutes, this court said the more recent specific statute governs and gave the marijuana back to the patient. I submit it's the same situation here. The A3 prosecution, if you look at it standing alone, you don't have a defense under 281381D. If you looked at just that, you could still go forward on an A3 charge. I believe the Arizona Medical Marijuana Act now provides immunity for a defendant in that situation.
Wouldn't they have said, wouldn't they have precluded criminal sanctions under A3? Wouldn't it have been much simpler to just say under A3 as opposed to unless there's marijuana or its metabolite in sufficient concentration to cause impairment? I mean, doesn't that suggest that it's just insufficient concentration that it could cause impairment regardless whether a jury would necessarily find impairment, impaired driving?
Again, I agree that it could have been drafted better, but when I think about who was drafting it, it was the Marijuana Policy Project. And there was an article last year where they talked to the campaign manager who addressed this issue and came basically out in the Arizona Republic, his name was Andrew Myers, and said there's no way a prosecution for just metabolites could go forward. And yet that's what we would be doing if we allow prosecutions under A3 to continue. I'm sorry, go ahead.
If I could ask you here, don't we have more than just a metabolite, though? Don't we have the drug itself?
We do, and I think ARS 362802D, the immunity provision, does address that because it does say the presence of metabolites or components of marijuana that appear in insufficient concentration to cause impairment. And I submit that's what we have here. I understand the court's point that 4 nanograms THC doesn't necessarily mean there's no way that person could be impaired. But in this situation and in other situations, a jury found not enough to prove beyond a reasonable doubt. And I think, again, if we're going to allow the A3 to go forward, we're not giving any credence to this language because, again, before this was passed, you had the same argument.
Does the state still charge A1 and A2 with over 0.08 of alcohol? And isn't it conceivable that a jury could acquit under A1 yet still convict under A2?
Yes, absolutely. I guess the distinction is I've never seen the state go forward on an A2 without any evidence that the person was over a 0.08 or over a legal limit, and we don't have a legal limit of marijuana, and again, because we don't have a general scientific consensus of where that limit would be.
And in this case, counsel, I mean, you wouldn't disagree that juries can do strange things. I mean, and they can have inconsistent verdicts as well. I mean, so I don't know how much we can rely on this particular record. I think your point is, we need to construe the statute as written the best we can, and you're suggesting that your client should be held not liable, criminally liable as a matter of law, correct?
Absolutely, because again, I think that our focus is to give intent, to find the intent to impose the will of the people. And the people who drafted this voter initiative, who passed it, clearly were trying to protect not just the possession of marijuana from criminal liability, but the use. It's throughout. It talks about the medical use and possession. And this is a situation where if we were to allow people to be convicted of simply having metabolites or of amounts of marijuana that were insufficient to cause impairment, we're essentially taking medical marijuana patients off the road. And I just can't believe that there was any way that the project intended to do that when they drafted this.
Let me jump in for just a minute, and this will probably muddy the waters even more, but following up, I think, on what Judge Brown just asked, I'm struggling with whether the statute 362802D imposes an objective standard, in which case I think we follow a certain analytical framework, versus what you're seeming to suggest, and you've got a good fact going for you in that the jury acquitted on the A1 charge here. But as I read the statute, it seems to impose an objective standard, presence of metabolites or components of marijuana that appear in insufficient concentration to cause impairment. Isn't there some notion that that would trigger the duty of the defense to present some sort of testimony, either through another criminalist expert or through cross-examination of the state's criminalist, to establish that in this case the prosecution cannot go forward because under any set of facts there's insufficient concentration to cause impairment? I mean, I think it's good to talk about the jury verdict from your perspective, but I'm not sure that's really where our focus is in determining what the statute means. Did that make any sense to you?
It absolutely did, Judge Downey, and I believe there is a case, again, that talks about the Arizona Medical Marijuana Act that, and I'm just trying to find it, that the immunity goes towards, is the court's decision. The court decides whether or not the immunity provision applies.
Question of law for the court, not a fact for the jury.
Correct. And if there is a question of fact, the case said that you take it to the jury, and the jury decides the fact, but the court ultimately decides whether immunity applies or not. And I submit that that's the situation in this case. It's not a fact for the jury. It's not something that the defense needs to bring up. My position, my argument, my firm belief that the intent of the law was to say if the person was using correctly and they were a registered qualified medical marijuana patient, the A3 prosecution should not go forward. Unless there's any other questions, I'll reserve my final couple minutes for rebuttal.
Thank you. Mr. Jones.
Good morning. I'm Craig Jones. I represent the state of Arizona, the Mesa City Prosecutor's Office. When I started this, it was a special action concerning the issue as stated by the petitioner was specifically, did the affirmative defense for DUI apply? He got up here and conceded that, so at this point, I feel like I won, but obviously there might be other things that are going on here. The court seemed to be interested in the interpretation of 362802D. I know the defense the petitioner is arguing that that is solely a flat ban on the A3. But I think when you look at the language there, the language is very specific to under the influence and impairment. And the only charge that really goes to is the A1 charge. So the state believes that it's not a immunity specifically to the A3. The defense has said, well, I keep saying defense, but petitioner has said that, you know, what else can this mean? Well, I think when you look at the words under the influence, doing a little research, I think the legislature first used that in the DUI statutes in 1927. And in 1929, the Supreme Court basically found that this was a well-known or a well-understood term, but a lot of the questions went, and it was Haston v. State, that they were basically saying everybody was afraid, well, if I have one drink, am I impaired? Am I under the influence? There were those type of questions, and it went on several cases where they're trying to do that at the beginning of doing this. The state's contention is this language is the same sort of thing. They're basically saying under the influence has a specific meaning. It talks about you have to be influenced by the marijuana. Impairment, that's a physical impairing thing, not a specific is the quantity in you. So the state believes that this is discussing particularly the A1 charge, and it's essentially saying that no, you have to have the impairment, you have to have more than just it in you at this point to prove the A1 charge.
Is there an amount, sorry to interrupt, but is there an amount, a quantity that the state, that experts agree is insufficient to cause impairment? If you're under 2, would the state go forward with an A3 prosecution?
I don't believe at this point there is any number that is universally accepted by experts. You will find individual experts who may give their own opinion as to a specific level.
But didn't the state's expert here say if it were below 2? I may be reading too much into that. But if it's not in there, let's say if it's the state's position that there's no scientific basis for saying that you could not be impaired, doesn't that undermine 382802 if you're saying you can in fact be convicted of under A3 with the most minute amount and simply a metabolite in your system?
Well, I think you said Harris. I've always said Shilkavorkian. It kind of answered that one. That a metabolite alone.
Not today.
Well, on that point, just so you're aware, the Supreme Court issued a decision at 10 o'clock this morning.
Yes, I'm referring to that. I read it on the way
I didn't know
down
if
here.
you were aware of that, but yes.
Yeah, no, I did read that, and they're basically saying, I mean, that it's an absurdity to say if you have an inactive metabolite in you that's what this prosecution's about. I think that fits in with the 362802D, the fact that you're saying if there's nothing in there. But I think as far as an active drug in you, I don't think there's a sufficient scientific basis, a generalized opinion knowledge, kind of like the 08, where everybody agrees you're impaired at an 08. We don't have that yet scientifically. So the state believes that it's still reasonable for us to say any amount of active drug in you is you can be prosecuted under the A3.
How about if there's not an active drug, if it's a metabolite only?
Inactive metabolite or active metabolite?
Well, after Harris, active.
Active.
Yes, as long as there is an active drug that's in 133401 in the person's system, we're talking specifically marijuana here, then yes, the state believes that A3 can be charged because there is no scientific.
Harris only involves an inactive metabolite.
Correct.
But there's some broad language in Harris, and I'm looking at paragraph 19 of the opinion that talks about 1381A3's placement in the statutory scheme demonstrates a legislative intent to prevent and punish impaired driving. And the preceding paragraph also talks about the legislature sought to prevent impaired driving. I know none of us has had sufficient time to fully digest the ramifications of this, but it seems to me there's some language in there that could undercut your view of how A3 is applied. Do you feel competent to opine fully about Harris yet, or probably not?
Not fully, no. But I guess the position would be at this point, I don't believe there is a general scientific agreement as to a level that you can say 100% this person is not being influenced in any way by this drug. You may have an individual.
Well, then what's
person.
The point of having 2802D? Then you should just never drive if you've if you've consumed marijuana in the last week. Is that the takeaway?
I believe that, yes, that's kind of what when the cases that found for the state, the constitutionality of their predecessor statute on this, I think we're basically saying this is a public safety issue, and
The predecessor statute, what are you referring to?
A3, it was 693 A3. when-
A3 just talking about.
Yeah, I'm still talking
illegal
about
drugs.
A3, but I
So
just,
heroin, whatever the drug, and we created just essentially the legislature created a strict liability essentially for certain drugs, but now in light of the Medical Marijuana Act, it seems like there's a clear intent to remove strict liability for simply having taken a drug at some point if it's not actually impairing or at least could cause impairment.
well, I guess I disagree with the interpretation that it's trying to take away that aspect of it. I think they're still looking at the fact of if the person is using marijuana regularly as a safety to the public, I think the state is saying that person should be cautious about when they're driving versus the entire public should have to be worried about people who are using marijuana and think they're immune from this.
But what's the guidance that we give people? When can they drive? Can they drive as long as there is an amount in their blood system that's in insufficient concentration to cause impairment, or if it's actually an amount that causes impairment?
I think you'd have to say if it's been metabolized through their body sufficiently that there's only inactive metabolites, then obviously they're fine. If there's still recent enough use that it's going to have an active, either the parent drug or the active metabolite in their system, then they should not be driving. That's the A3 part of it. We're saying we don't have enough science to know exactly, so we're kind of back to, I mean, we're talking marijuana here, but I mean, these haven't been studied sufficiently to say, give us a specific amount. I know some states, by initiative, have put a number on it, and that's based on some scientists' opinions on that. But
the number that your expert came up with, or that the state's expert came up with, is that a number that's used elsewhere in other states? And I apologize if I'm misremembering, but it seems like it was 2.
I'm sorry, I don't remember that specifically in the record on this. The only 2 states that I know of are Colorado and Washington, and they're 5 nanograms per milliliter of the active parent THC in their body is their per se limits. Those were passed in Washington, I believe, in both states by a voter initiative.
Anything under that, so Mr. Darrow would not be prosecuted in Washington or Colorado?
Under their per se law, no, because they had the
But they're
5
per se
nanograms.
meaning their equivalent of A3?
Yes.
Okay.
Yes, that's correct. In those states, because they set a specific limit saying over this amount is when you are per se found in violation of this statute. He, in this case, since he was 4 nanograms, would have been
And
under the
why
cutoff.
isn't that kind of a reasonable interpretation of the language of 2802, that we don't want you to be prosecuted unless you're over 5?
Because they don't say that. That's why I believe it's not a reasonable interpretation, because they were very specific in other parts of
Agree
this.
that they didn't intend. You would agree that they intended at some level. Let's say it's at 1 or 0.001. Wasn't that the point of the AMMA, to have some level at which people would not be prosecuted merely for the presence of the drug in the system?
Our intent is hard for me to gauge on this. I think when you look at the Arizona Marijuana Policy Project, who sponsored this, their goal is legalization of marijuana. So if you want to say their intent then would, of course, to be either legalize it without criminal penalties for any sort of marijuana.
This is talking specifically about driving, and it's saying that there's some quantity that we do not want to criminalize. If that's your only basis for arguing that someone is under the influence solely because there's some very low level that should not be criminalized. So that's the law that that we've passed, right?
It is, but I think it's very vague when you talk about insufficient concentration, absence a known and agreed upon level at which it would be insufficient. So we're still kind of back to the same question. I mean, had they been able to put a number in there, then it would be very clear what their intent was. Had they used language like they did in other places where they said in like 2811, where they say you cannot prosecute, arrest, any of these things for these offenses, that would be clear. But what we have is a specific references to impairment, to being under the influence, and a thing about insufficient quantities when there is no general scientific agreement as to what that is or what that even means in that level.
Or can we say that it just becomes a jury question, and that if the state has an expert that said this is insufficient, or that this is sufficient to cause impairment, the jury would have to decide whether the defendant has his own expert or cross-examines the state's expert, and would that be a reasonable test to follow?
I think I've seen that actually given as a jury instruction in the A1 case, where the courts have used that language as part of the A1 case. I've never seen it given as part of the A3 case.
But so how does the determination get made? Mr. Tatz was suggesting that it's a question of law for the court prior to trial, and that's one plausible way of doing this. And the other question I have is, in this particular case, is it of any significance that the jury acquitted Mr. Dara on the A1 charge, finding that he was not impaired as a matter of fact?
I'll start with your second question first, and hopefully I'll remember the first question. I don't think that the not guilty verdict is what was intended by this. We're saying, as the court's pointed out in its questioning, you can have inconsistent verdicts. When it talks about insufficient quantities, are we looking at here where the jury can say, well, there may have been sufficient, but we just didn't see the impairment? I don't know what they found here, but they did find guilty on the other one. So I don't.
In some ways, that's akin to jurors that acquit on an A1 alcohol charge, but convict on an A2 alcohol charge, notwithstanding the fact that even defense experts agree that .08 and higher, everyone's impaired. So to some extent, I get where I think you're going with that, but I'm just thinking, who decides this issue and when? How does it get presented to the court, and on what basis is it decided?
Well, that's a interesting question. That was actually some of my notes, is to ask the confusion to this is exactly that. I mean, the petitioner wants to say it's a flat ban, but when you look at it, I'm not sure if it's a factual question for a jury or for the court, and it seems to me that it's closer to some sort of like the affirmative defense, and for the DUI, you have to show that you qualify under this exemption, that you have that drug in a level of you that's insufficient to cause impairment in order to do that. So I think
Then a question for the court to decide pretrial?
I believe it would be.
But don't affirmative defenses, like, those go to the jury, right? Doesn't that affirmative defense that's been conceded here, wouldn't that have been a jury question still? Or not?
Well,
or I don't know. Maybe we don't.
it could have been. I think if they're trying to raise affirmative defense, they have the burden, as I understand, by preponderance, to raise the burden before it goes to the jury. In this case, I don't think it would have got to a jury because of the naturopath thing here. So I think a court at that point could have said, you can't even meet the threshold here that you can use this affirmative defense. So I think in that aspect of it, it would be a legal question specifically. Had you been able to get past that, then yes, the affirmative defense is something that has to be decided by the jury.
Let me throw one more twist in here to really confuse things. It says, is retrograde analysis within the realm of possibility to relate back? Let's say maybe the testing was done 48 hours or 3-4 hours later, or even a day later, the testing of blood. Could that be related back in some fashion? Do they do the same type of analysis that they do in, I don't know the science, but as they do in a DUI or in an alcohol context?
I don't believe that the knowledge base on marijuana has developed the same as alcohol, that they can do that. That's my understanding at this point, that's probably not currently in the realm of an expert's ability to do that.
So it's basically, it's the reading is what it's the test result is what the test result shows, and that's pretty much what the expert's going to, and the expert's going to be tied to that for right now.
Well, what I think they would say, when you have an inactive metabolite in the person, the expert can tell you that, okay, that may have, the active ingredient, active drug may have just been metabolized right when he was being stopped by the officer, right after he drove, and we test it, we get the blood an hour later and we test it. It could have been some amount of active in him, or it could have been, if he was a intense marijuana user, it could have been in his system for weeks. So there's no precision, as I understand at this point, to be able to do that sort of a scientific retrograde calculation on that. I guess just one last point. I just think the state's position, I think if they were attempting to do that, and I could say that, probably that may have somewhere in there was part of their intent, but I think there still has to be language that says this is a flat ban, and they didn't do that. In fact, they referenced specific language only from an impairment charge in there, and I think when you look at the face of the Medical Marijuana Act, you can't get to the point of saying this is a flat ban against an A3 charge for somebody using medical marijuana. It just doesn't say that. The language isn't there.
Even for .001, you can still go forward with an A3 prosecution, even if it's at a level that everyone agrees is insufficient to cause impairment.
That's the interesting question. I think if you can have consistent scientific evidence to that fact, then that would probably be a prohibition. Our position be that at least now there is not.
Did say that.
Pardon?
I was reading your expert to say that there is some level at which it's insufficient to cause impairment.
I know there are experts that will say they believe, I've heard at least one expert say 2 nanograms. He would believe that impairment would be fine for anybody above 2 nanograms, so that would probably, I guess that by thing says 0 to 2 may be a non-impairing. Unless you have other questions, I don't.
Mr. Tetz? Yeah.
Thank you, Judge. Just to go back to the case that I was referring to before, it's State versus Fields. It's actually cited in Real Party and Interest brief. It does talk about that immunity is for the court. The defendant has to plead and prove it by a preponderance of the evidence. Once that has been established, though, the court does decide if immunity, and it's in paragraph 15 of that decision. Secondly, I would just assert that petitioner did preserve the issue of immunity for this court. It was pled at the trial level. It was argued at the lower court appeal level. It was in my brief.
How are you suggesting it happens? Is it something that would require just expert testimony to the court before it goes to the jury? How does the court know if there's marijuana or its metabolite in sufficient quantity to cause impairment?
Judge, again, I would submit my interpretation of it, and I believe that the voters' intent of it was that you wouldn't have to do that. You would simply have to show the court that you had a valid medical marijuana card, that you were a valid registered patient. Once you've done that, I believe you've then met the immunity provisions to
Subject to A1.
To have the A3 dismissed, and then it goes to the A1. The last thing I would point out is there was a little bit of discussion about the cases that upheld the constitutionality of the per se drugs laws, and those are in my brief, State versus Phillips and State versus Hammond. And key in both of those decisions were the fact that there was this secondary objective that the court found, that you're also deterring illicit or illegal drug use. And they said, even though you may not be necessarily, you may catch more people than you need to, it may be overbroad in catching people who are not a danger on the road, who are not impaired, you still have this secondary objective of deterring illicit drug use. That is no longer the case with medical marijuana. With medical marijuana, it's not illicit drug use. If the person has pled and proved that they have a valid registration, they should no longer be subjected to per se prosecution for choosing to drive. And unless there's any other questions, I'll be done.
No, thank you.
Thank you.
Thank you both. And on the court's own motion, we hate to make more work for you, but we would like to have additional briefing in light of State versus Harris. And I think if we were to ask for 10 pages,
Maximum.
10 pages maximum, filed within 10 days, we'd at least like to give you that opportunity to file supplemental briefing not to exceed 10 pages within the next 10 days, and we would be happy to consider that.
And I think we're talking about addressing what effect, if any, State versus Harris has on this case. Is that,
Right.
so not just supplemental briefing on anything you want?
And with that, thank you both very much for your arguments. Very interesting case. We will take this matter under advisement after receiving your supplemental briefing and issue an opinion in due course. Thank you.
So in Turbo Court, is there a supplemental brief thing?
You're going to be finding out.
I wanted to ask one other.
Yeah, last time I came down and filed something, I walked in my 15 copies and dropped it off. Good job. See you later, Craig. See ya.
Nice to meet you.
Nice to meet you.